just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
This is not a clown show. Plaintiff admitted that too. So the defendant has failed to appear. He's failed to support his.
This court hearing is nothing short of a spectacle. The no-nonsense judge dismantles this sovereign citizen's ridiculous arguments with the efficiency of a laser-guided missile. No patience, just pure precision. Meanwhile, the defendant, less his misguided confidence, attempts to outwit the legal system armed with nothing but internet conspiracy theories. Instead, he unintentionally admits to his own crimes, as if auditioning for a reality show called How to Incriminate Yourself in Seconds. It's wild, it's absurd, and it's pure courtroom entertainment. Buckle up and let me know which moment had you laughing the most.
Refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I opened written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead.
The audacity on this guy is unreal. Does he not grasp that he's running his mouth at the one person in the room who can personally upgrade his living situation to a jail cell? He's out here dodging financial responsibility like it's some high-stakes game of legal hide-and-seek, fully convinced that acting clueless is a winning strategy. Spoiler alert, it's not. The judge, who has undoubtedly seen this act play out 100 times before, slices through his nonsense with surgical precision. Every excuse, every flimsy argument, wiped out in seconds. The real question is, does he actually believe any of this, or is he just hamming it up for the audience? Either way, it's peak courtroom comedy. Drop your verdict, delusional or just deeply committed to the bit.
You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I didn't have no I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the
Before we jump into round 2 of this legal circus, I have to ask, do you think this guy is actually delusional, or does he genuinely believe he's outsmarting the judge? Because let's be real, the confidence he's radiating does not match the nonsense he's spewing. This man is fully convinced that ignoring official documents somehow makes the whole case disappear, like the law is a spam email he can unsubscribe from. Does he really think marking an envelope returned to sender is the legal equivalent of hitting undo? It's almost impressive. And let's talk about his attitude. He carries himself with the misplaced swagger of someone who thinks they've cracked the legal system wide open, while the judge, calm and visibly done with this nonsense, is just waiting for the right moment to shut it all down. This guy thinks he's playing 4D chess, but in reality, he's just knocking over the pieces and calling it a win. He's so detached from reality, you might as well need a passport to get back. So what do you think? Is he actually this clueless, or is he just putting on a show? Either way, buckle up, because the judge's final ruling is coming, and you know it's going to be satisfying. Let's get into it.
Interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit, number 6, and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7.
That was absolutely legendary. This guy just managed to snitch on himself in the most spectacular way possible by openly admitting to the very debt he's desperately trying to avoid. Like, who does that? The judge barely had to lift a finger. They just sat back, probably in mild disbelief, as this man single-handedly built the prosecution's case, tied a bow on it, and handed it over. Honestly, it's like he walked into court with a PowerPoint presentation titled, "Why I'm Guilty," a step-by-step guide. And let's take a moment to appreciate the judge here. Absolute MVP. They even threw this guy a lifeline, straight up telling him to get a lawyer because, clearly, he's out of his depth. But what does our guy do? He refuses, probably convinced he's some kind of courtroom mastermind who's cracked the system. Spoiler alert, he is not. The judge dismantled every ridiculous excuse with such brutal precision that you'd think they'd been waiting for a case this absurd just for the entertainment value. It was like watching a professional chef dice a potato, clean, efficient, and oddly satisfying. And let's get real, the facts are crystal clear. The man owes the debt. The evidence is undeniable. The judge even spelled out his options. But instead of making the smart move, he doubles down on nonsense, acting like returning mail is some kind of get-out-of-court-free card. Spoiler alert number 2. It's not. Ignoring your problems doesn't make them disappear. It just makes the consequences hit harder. And if there's one undeniable truth from this case, it's that some people have an incredible talent for making things way worse for themselves. So what do you think? Was this guy genuinely clueless? Or was he putting on a one-man show for the most bizarre courtroom performance ever? Either way, it was pure comedy gold watching him dig his own grave with every word. Let me know in the comments if you found this as hilarious as I did. And don't forget to like and subscribe for more courtroom chaos. This one's going in the Hall of Fame. Thanks for watching, and take care.